All right. Hello, Ellie. Welcome to the show. How are you today?
Hi, I'm good. How are you doing?
Oh, I'm great. I'm excited to talk about something we talk about a lot on the show, actually, estate planning. But specifically, what I'm excited about in this presentation, which, by the way, we've seen as a part of a client event before that you did for us, Ellie,
hmm
but it's just showing examples of how proper estate planning is so critical because if it's not done right or it's not updated or whatever the situation is, like things can go wrong, right?
Yeah.
So I'm excited to have you present on this. But before we jump into it, could you just tell our listeners a little bit about who you are and ClearEstate?
Yeah, sure. So I'm Ellie Muir. I'm the team lead of partner relations at ClearEstate. So I have the wonderful job of reaching out to folks like you, Joe, and people at your office to talk about estate planning and about how we can help your clients with getting their wills and power of attorneys done and integrating your wonderful guidance into their estate plans. And ClearEstate can get the documents executed that way. So we're a great coordination of services, I think, Matthews and Associates and ClearEstate. I've been with ClearEstate for over a year now. We're a younger company, so that's kind of getting into veteran territory in terms of being at the company. But before I joined ClearEstate, I worked for a decade in the fine art auction industry, actually. So I spent 10 years at Canada's oldest auction house, and I ran the appraisals department for quite a long time. So I spent many years talking to families who were going through the estate settlement process and needed appraisals of their fine art and needed advice and guidance about bringing that art to market. So when I saw Clear Estate, I just thought what they were doing was so interesting and a new way forward in terms of servicing people through a sensitive topic and a difficult time and making sure that things go more smoothly for them. So that's what drew me to Clear Estate. And today we're going to talk about stories that we have gleaned from our over 2,000 estate settlements that we've completed. Of course, changing the identities and some details here, but these are real stories that we encountered while we were helping people through the processes. So it's a great learning experience.
Awesome. And I learned something new about you today, too. Uh, just a reminder for our listeners. So Ellie actually has some slides to go with this podcast episode. So if you want to get the visuals, you can find it at the Retirement Planning Simplified YouTube channel. All right. So with that, Ellie, let's jump into Estates Gone Wrong.
Yeah. So, just off the top, it's important for everyone listening to realize that only 48% of Canadians have a will in place. So, if you're listening to us right now and thinking, that's been on my to-do list for such a long time, you're not alone. And in fact, of the people who have a will, only 35% of them say it's up to date. So, just about everybody can use a revisit to their estate plan, whether it's the first time or it's the first time in a long time. Definitely bring up the conversation with Joe, and he's going to be able to help you there.
And I would
But
say maybe if I add on to that, Ali, one of the things that I notice is that a will doesn't have to be, I guess, too far removed from its implementation date to be out of date at this point. With all the digital assets, things like that, I find that most times that's not addressed in any way. So that's just like one small thing for people who even think maybe their will's up to date and have done it in the last few years. That's just one piece that we see missing all the time.
that's right. And we find that it's kind of, we're trying to change the narrative about estate planning and wills. It's no longer, pull the document out of a file cabinet and blow off a layer of dust because it's something that was written 30 years ago. A will should be up to date, and that can happen throughout someone's life where things change as you expect, like people evolve over time. Every 3 to 5 years or so, typically something has happened in your life that's worth reflecting in your estate plan. So make sure you kind of make it part of your regular exercise of making sure your life is in order and things are up to date. It's super important when it comes to making sure your legacy is the one that you intend to leave. Yeah.
For sure.
So I can get into the stories now. You can see here we're starting on something called A Very Generous Gift, the story. And it's about Bob and Sally. So these two, had long successful careers. They had two children, and they have a charity that's really important to them. It's something that they really wanted to incorporate into their estate plan and into their will. So they decide together they're going to leave $300,000 to this charity. The rest will go to their kids. And, they felt that that was a pretty reasonable thing to do. Now, after they've retired, they live a long time, and they both develop advanced age diseases in their 70s, which is becoming more and more common as Canadians live longer and longer. It's something to keep in mind. Bob passed at 78. Sally went on until she was 85. But the cost of their care was expensive, and it really reduced the value of their estate by quite a lot. So when they created their estate plan and their will, their net worth was 1.5 million. 300 grand to the charity was 20% of their estate. So that seemed reasonable. They were happy about that. But because of the care that they required, at passing, their net worth was $500,000. So that means the charity was getting 60% of the estate and the kids only 20% each, which certainly wasn't what they intended when they first made their will and their plans. So this, just as we were saying off the top, Joe, it's important to revisit. If things are changing in your life, make sure you're going back and ensuring that things are aligning properly with what you want to have happen, right?
Yeah, and I think a change isn't necessarily like a life change, right? But it could be a change in net worth. So you
Mm-hmm.
spent down some of your savings, or alternatively, you have a lot bigger net worth than you planned because you didn't spend as much as you could spend, right? Those are both changes that isn't like there's a turning point or an obvious time where you should revisit. It's just something that gradually happens. And another place we see this actually quite a bit is where we would see a specified gift maybe for grandchildren, and the
Mm-hmm.
idea being that not that they want to give the entire inheritance or estate to the grandkids, but they want to help them out, assuming their kids are going to get the balance of it. But again, the shrinking estate idea can show up here if things aren't addressed or updated
Yeah.
over time.
Yeah. So talking to experts, making sure you're going through all the options that are available to you. And in this case, it would have been a simple change where they change from a specific gift to incorporating the charity as a percentage of the residual amount within the estate. That would have solved the problem. And here's the next one. So this is about record keeping. Okay, making sure that you are keeping good records when you have to undertake the care of somebody. So this is about May. May has 4 children, and as usual, she appoints her eldest child, her daughter, Juliana, as her executor and power of attorney. May develops dementia at age 75 and lives for 10 more years. So there was a lot of care involved, a lot of expenses, kind of similar to the last case. Juliana spends hundreds of hours ensuring all of May's needs are taken care of. She loves her mother, she keeps her comfortable, and she ensures she gets the best care possible. The thing is that Juliana's siblings see that the estate has diminished a lot. They don't understand why so much of the inheritance has disappeared, and they're wondering, did Juliana do a good job, or did she go overboard, or did she, misappropriate some funds? So even though Juliana had acted prudently while she was caring for her mom, she couldn't produce sufficient evidence to back that up. She didn't keep every receipt. She didn't, explain as she was going along how expensive it was to have home care and different medications, whatever it might have been. And the result was that Juliana's siblings took her to court, and it costed thousands in legal fees. It delayed the settlement by a lot, and most importantly, and sadly, it fractured the family relationships. So you'll see this quite a lot. Siblings get along great, but after mom passes away, their behavior towards each other can change. And this is a case of that where Juliana did the best she could, but the siblings didn't understand the extent of the work that she had done. So many estate conflicts arise when siblings perceive they're not being treated equally. Yeah. And so feelings come to the surface. Um, what's the solution here? It could have been having a professional, right? So a professional power of attorney and executor would have kept really detailed records because that's their duty. They have to do that, right? And it would have been easy to demonstrate why the estate was the amount that it was by the time they passed away.
Yeah, and I think that's something that people don't consider enough is there another option other than having family carry on these roles? So definitely
Yeah.
something to consider.
Yeah. Power of attorneys can be a short engagement or a very long one, right? And in this example, you saw hundreds of hours were spent. So that's something to think about. This next case is something that is probably quite common, which is parents making plans for a child with a disability. So making sure that their child will be well taken care of after they've passed away. In this case, we're talking about Dawn and Mary. Dawn and Mary have two daughters, Sandy and Leah. Leah has a disability, and her circumstances are factored into their estate plan. So Dawn and Mary make sure that that's taken into account when they create their plans. Dawn passes away first, and Mary receives, quote unquote, some advice from her neighbor to make her kids the beneficiary of a life insurance policy. So Mary does that. She assumes that that is a wise thing to do. She's not consulting with experts here, and she doesn't bounce the idea off Don. Unfortunately, he's not able to help at this point. So she doesn't check with anyone and just makes the change, thinking it's the right thing to do. She trusts her neighbor. Her neighbor's probably a well-intentioned, intelligent person, right? But not with the same circumstances as Mary. So what happens? The issue is when she updated the beneficiary designation, she inadvertently revoked the initial planning. So the initial planning would have made sure that Leah didn't inherit so much at one time that her government benefits were discontinued. That can, when you go to file taxes and that kind of thing, the government will say, well, you know, nope, you don't need this anymore. Obviously, you've got a huge income for the year. And I can see you nodding, Joe. It's all too common, and it's something that can be easily remedied with the right planning, which unfortunately Mary sort of steamrolled over when she made one simple change. That isn't that hard to do, right?
Yeah.
So what's the lesson? Work with experts. Communicate your plan. I mean, that we're here to help. You make sure you bring up your concerns. You know, it's a time to revisit your plan after a spouse passes away. Make sure you've got everything in place.
Yeah, and your
and
planning needs, as I say, your
ahead.
planning, like, it needs to take in the big picture, right? So if you do planning in silos and your advisors aren't coordinating, that's how these types of things can happen, right? If everyone's coordinating and when you make decisions, yeah, your advisors are involved, it can make sure that we're cutting this off before it happens. But we're dealing with a similar situation right now. And there's a little hesitancy to move on the best way forward, because in this scenario, maybe a Henson Trust is ideal, but maybe they don't need it. And anyway, so they kind of have it in place, but they have other things, basically, like you just talked about, that will kind of blow it up if something were to happen. But also a spouse recently passed away, and it's just kind of difficult to make decisions. So it's something we're working through, but it's easy to happen. Is literally, like you said, just the beneficiary, like, could kind of, just blow up all the planning that you've done.
Yeah. So, and another angle here, and something important to consider, is Sandy, right? The other sibling. So Leah's lost her qualified disability payments, but Sandy is now having to mourn the loss of her mother, but also navigate how is she going to help Leah. And also, if they had put a trust in place, the burden on Sandy would have been long. It could have gone on for decades where Sandy was a trustee. So again, like a great situation where it might be a good idea to consider a professional executor and trustee when you're revisiting your plan for a situation like this.
For sure.
Yeah. So the next one, this is an interesting one about a trust. So someone has created a testamentary trust in their estate plan, but it doesn't quite go according to the decedent's wishes. So we're talking about John. He has a wife. It's his second marriage, and he wants to ensure that his wife Megan is well taken care of after he passes. She's accustomed to a certain lifestyle. It's important to him that she maintains that after he's gone and enjoys the remainder of her life as well. So he creates a spousal trust. The trustee of that trust will be his son from a previous marriage, who also will inherit the remainder of the funds in the trust when Megan passes away. So in his will, John had included broad discretionary powers to his trustee to encroach on the capital of the spousal trust for his wife's benefit. He makes his son Henry the executor in this case. So John's intention is to make sure that Megan is taken care of. However, what happens is his son Henry is in a clear position of conflict because he does not prioritize income-earning investments in the trust and interprets his discretionary powers to encroach very narrowly. So this is a lot of financial speak here, Joe. Do you want to translate a little bit what's happening here?
Yeah. So income, at the end of the day, the spouse or the trust is probably saying that the spouse will get the income earned in the trust, but
Hmm.
if Henry's not investing in any kind of investments that are producing income, like dividends and interest, for example,
Hmm.
and it's just all capital growth, then Megan needs to asks, and basically Henry has to okay any
Yeah.
additional capital coming out of the trust. So it then becomes, yeah, Henry's discretion whether Megan actually gets any of that money. And
Yeah.
if she was relying on that to be taken care of, then the trust really isn't serving its purpose.
Right. So John would hate to hear that this is what's going on in the end, where Megan is, having to make these really detailed requests to Henry just to maintain the regular level of life. Probably nothing extravagant here. So it's really important to think through these scenarios and never make assumptions that people are going to behave the way you would in that situation. You know, Henry's basically acting as proxy for John here to make sure that Megan is well taken care of, but the result was not what John intended at all. I'm sure the relationship was quite strained, and it was no fun at all for Megan to be in that situation. So, the lesson again, if it's going to be a trust that you're setting up in your will, think about these conflict of interests. Don't place that pressure on the trustee in the future who's going to have to be neutral, right? And sure, there are lots of people who are capable of behaving properly in these situations, but we're all human, and we're going to act in the best interest of ourselves a lot of the time. So it may not even be on purpose that this behavior is taking place, right? It's just people are looking out for themselves. So think about, again, a neutral third party who could be in charge of this to make sure that the wishes of John, the decedent, are being carried out and followed.
Yeah, we actually have another client who is the trustee of not a spousal trust, but a Henson trust
Mm-hmm.
um, for their sister. And while she is, she takes care of it, she's on it. It also really stresses her out. She's always scared. What if I do something wrong? I don't track things properly or whatever, and I screw up
Yeah.
the Ontario disability payments. So it is a bit of a burden. I know she probably wouldn't use that word, but that is, I know she feels a lot of weight on her shoulders to do all this, right? And I know that even though she will do it, as long as she is here to do it, on the same hand, it would be a relief. There would be definitely a sense of relief if there was like a professional trustee taking care of
Yeah.
that instead of her.
Yeah. It would just remove that layer of relationship between the siblings where they're just sisters as opposed to trustee and beneficiary. That's a whole other hat to be wearing. So yeah,
Yeah.
certainly makes things easier for people. This one is kind of an interesting one about when we get those dusty old 30-year-old wills. And keep in mind, ClearEstate is having these experiences because the other half of what we do is helping executors who are settling estates, right? So these
Right.
are all cases where we have not done the estate planning with the people,
Yeah.
I should clarify. So in this case, it's a really old will. So it's about Bill. Bill's a proud grandfather. Olivia, Emily, Liam, Charlotte, Noah, and James Jr. He has three sons, John, Jack, and James. He includes a per stirpes distribution to his sons within his will. So that means per stirpes, it's an old Latin term, meaning kind of like following the bloodline. So in this case, the example is that one of his sons passes away. According to per stirpes, that means the proportion that would have gone to that son, Jack, who passed away, is then equally distributed to his children, right? So it's
Right.
one of those cases where you're writing a will and then hopefully it just covers every scenario possible and you don't have to revisit it. But there's danger in that. So um, Bill's lawyer included an outdated template that had an out of wedlock clause. So you could probably see where this is going. Modern families today, they are not always getting married when they establish a family, right? And so this is kind of a bad result here. His lawyer wasn't aware that Jack was never legally married to Liam and Charlotte's mom. So the result is that Bill's grandchildren, who he believed would inherit in their father's place, received nothing, and his estate was split between his surviving two sons. So, perhaps this could be resolved with good family relations and there can be some equalization after the fact, but that's not guaranteed. You want to make sure that it's set in place ahead of time to happen properly. So um, estate planning requires complete discovery of all relevant circumstances. So that means a good planner is going to say, okay, per piece makes sense. Is everyone married? Do you want to have any if then situations accounted for here? Um, it just needs a fine tooth comb, right, to benefit from a proper discovery of all family circumstances and make sure that you're using a service that doesn't have old templates and outdated clauses as part of the service that's provided.
Yeah, I think that the like people will run into that is some lawyers trying to be all things to all people, right? So
Mm-hmm.
they dabble in some estate planning, they do some real estate, they do some business like corporate law. And so when someone comes in for the estate planning piece, yeah, they have their template there to keep things efficient. But
Uh-huh.
is that template taking into account specific circumstances or being updated along the way as yeah, things change just in generally as like you said, the modern family, for example.
Mm-hmm.
Um, and so for sometimes those work, sometimes it's okay, but they're definitely not customized and often not taken into um, not thinking about specific circumstances of the client.
Yeah. And, perhaps Bill's lawyer had been in practice for 40 years and it had always worked and he hadn't had any complaints. But,
Yeah.
here's one of those things that can easily really mess things up for beneficiaries in the future. This next story, I think, will hit close to home for a lot of Canadians who have a family cottage, right? There's a lot of thinking to do when it comes to the family cottage. Ontario, sometimes the cottage is worth more than the house. You have to be
Yeah.
really careful about the planning here. So in this case, we've got Rashad and Keisha. They are the parents of two daughters, Janelle and Jennifer, and there are four grandchildren. Together, they have spent so much time at the family cottage. It's an important place, amazing memories, and everybody has just always loved visiting the cottage. And they want it to be something that their kids can continue to enjoy for the rest of their life. So they leave the property equally to their two children. Seems fair. However, when Rashad and Keisha pass away, there's a significant capital gain tax liability associated with the cottage and no planning for this. So that's going to be a huge tax bill. When you are settling an estate, the first person to get paid is the tax man, right? Like
Yeah.
that is going to be the first debt that gets paid up and squared off. And that can just take away every last cent of liquidity in an estate when it comes to cap gains, which can be very significant for a cottage. There's also no plan for how Janelle and Jennifer will actually co-own the property. Let's say Jennifer is an hour and a half away, but Janelle's three provinces away. Who's going to be using it more, even though they're 50-50? Who's going to be fixing the pipes when they burst in the spring? You know, um, all kinds of things. When the dock gets flooded and falls apart and starts floating away, you can bet it's going to be Jennifer instead of Janelle. So the result is the cottage property becomes a burden to them. And financially and emotionally, there is strain on the siblings, where the cottage is supposed to be this place of leisure and relaxation and family time. It's become this like unhappy situation, which is certainly not what Rashad and Keisha wanted to have happen. So, Joe, I bet you've got some great ideas here about what people can do to pre-plan for this. Like we can foresee this expense coming. We can foresee this happening. One thing that we should think about is let's talk about the implications here for the distribution. Let's make a co-ownership agreement. Let's think about what that expense is going to be and talk to Joe about how are we going to cover that off in our estate in the future.
Yeah. There's definitely some planning to be done there.
Mm-hmm. Yeah, I bet you've dealt with it with plenty of your clients who have a cottage in your area.
Yeah. That could be a
Beautiful
different
park.
episode.
Yeah, it could be a whole episode, right? So anyway, I mean, bottom line is talk to the experts in your life and make sure that this beautiful vision you have of the future where your generations are enjoying your family cottage is actually going to happen, right? And I think this might be the last one. This is about Nicholas and Pedro. They have two adult children, Isabella and Luis, and they have or plan to provide significant gifts to them upon various life events. So, getting married, buying their first house, it's important to them that they're able to contribute and keep launching forward their kids on the path to success in life. They do have a hodgepodge clause in their wills to equalize their estate. So this means, $10,000 to the child who gets married. We'll make note of that and deduct it from the inheritance in the future. So it's fair. By the time Nicholas and Pedro pass away, they have provided two significant gifts to Luis when he purchased his home and he got married. But Isabella did neither of those. You know, she was a single working professional renting a high rise condo, right? And that was the lifestyle that she chose. So, two very different things happened there. After they pass away, Lewis claimed he didn't recall receiving gifts, and there was unfortunately no proof that he had. So the result is that they received their shares of Nicholas and Pedro's estate without any equalization. So although they spoke about hodgepodge clauses without any documentation to prove that those gifts had been given, Isabella was in a tough space, and Lewis unfortunately just claimed that it had never happened, and it really strained the relationship. Lewis and Isabella did not speak to each other again, which is just so sad. So the lessons, again, all relevant facts must be carefully documented. So again, another case of documenting things. You can't rely on beneficiaries to be honest and forthcoming, and this is kind of a recurring theme we're seeing here. Inherently, people are good, right? But they're going to change their behavior slightly, especially at a stressful time when someone has passed away. Things are changing. There's a lot of money at stake. It may not be everybody's shining moments of their best behavior.
Yeah, for sure. I think that like obviously a lot of this is there's stress on relationships when things aren't properly done.
Mm-hmm.
People aren't always who you think they are when money's involved, but doing all the perfect planning is a great start. But then the next thing is, I think to help with some of these issues also is having like family meetings, keeping the family updated on your plans and your wishes and how things are set up. And then
Yeah.
if there is anything that's unequal or depending on who's chosen as executors, all these kind of things, it's where they could cause strain. It could also be dealt with when you're still alive to have those conversations with your family, right? So I think
Mm-hmm.
that also is kind of like that next piece. So the proper planning is number one, but then communicating, why you've done that planning.
Yeah, absolutely. Right. A lot of it is about communication. Um, and that's the end of the stories that I have. I
Okay.
hope they're
Well, that's
helpful.
Yeah, no, that's great. I think that really paints the picture that while maybe you've done some planning, right? You've done some estate planning, you think you've kind of ticked the box, things change. And estate planning, just like retirement planning, it's not just a one and done, it's an ongoing process that needs to be
Mm-hmm.
revisited. So before we wrap up here, Ellie, maybe you could, I know you said a little bit about yourself and ClearEstate, but maybe you could just talk to us a little bit more about how people can find you if they want to follow along, see what ClearEstate's up to or what you're up to. And also maybe a little bit about, where ClearEstate comes in, how they're maybe a little different than a traditional estate planning firm.
Yeah, sure. So ClearEstate can be found at clearestate.com. If you're a client of Joe's, bring it up to Joe and ask you about it, right? I'm Ellie at clearestate.com, and you can reach out to me anytime if you have questions. But a little more about us is that we are a new way of doing things. We are not the traditional, what happens behind the desk of a lawyer approach to estate planning. We are really much more modern approach where we have harnessed technology to make sure that things get done. All details are accounted for. We maintain the most up to date guidance when it comes to creating an estate plan. And we can do it in an efficient way that's easy to understand, simple, affordable, but still with a human in the loop providing you expert advice. We do all of our meetings virtually, and we are still able to create a great spot online called Clear Vault, where we can create everything you need to make sure your estate plan is really comprehensive and we aren't missing anything. Incorporating Joe's advice as well is the best way to do things, because Joe, you're there for your clients throughout their lifetime, building their wealth. They have different priorities over time, and eventually talking about their legacy is going to start becoming more and more important to them. And that's just part of what you do, right? You make sure we're completing that circle of services, and estate planning is that last link, I would say.
Yeah, and I'd say two things that we really like about your service is that one is the updates are included, so we're always having that conversation and reviewing the estate plan rather than doing it and thinking about it again 10 years later.
Mm-hmm.
And then I think the other piece is that it's you have kind of that comprehensive vault. So one of the issues that we see, so for example, one of our clients passed away last year, and they'd done the planning, but the issue was that the surviving spouse was not able to act as the executor. So the
Mhm.
children were the alternates, and so they got involved, but then they could not find where everything was. So they had a will, but they couldn't find all the other pieces that they needed, right? So
Yeah.
they're kind of all over the place, and they were really stressed. And obviously, we were able to help them with the stuff that was in here, but there was a lot of tears shed in our office and conversations around what they were trying to do, right? So
Yeah.
just as part of the estate planning process, rather than just having that templated will, it's also having that vault, making sure like everything is accounted for, we know where to find it, is just another
Yeah.
piece in having all the everything in the right place.
Yeah. Like you get a snapshot of your net worth when you do this exercise. We want to know what all of the assets are so we can talk about the right way to bring that forward through to your estate plan. All of your debts as well, right? Any liabilities that you have. And then we want to understand as well your family and the people that are going to be involved in your plan, charities. What are your most pressing goals? What is worrying you and keeping you up at night about your estate plan? We're going to solve for all of that and keep it in one place so that if you don't appoint ClearEstate as a professional executor, you can still appoint someone in your family who's nearby and capable. They're going to have an amazing starting point where everything they need is there, right down to like, we're going to suggest that you have a copy of your divorce certificate uploaded to the platform if necessary, how your house is titled. Like, let's have a look at all of that so that when it's time to apply for probate, boom, like you've got what you need and there's no tearful digging through the boxes in the basement for a certain piece of paper, which may end up being impossible to find, right? And that's a big delay. Yeah.
Exactly. Awesome. Well, that's been great. I know that again, that's I think really highlighted the need for doing this type of planning. So I appreciate your time today, Ellie.
Yeah, my pleasure. It's great to see you again
You too.
and
Take
look
care.
forward to working with you. Okay.
Thanks. Bye bye.
Bye.